The science of murder, the analysis of dangerous new psychedelic drugs, and the fingerprints and trace evidence left behind by suspects at crime scenes are just some of the topics that I'm going to be discussing with a panel of forensic science investigators later this month. And you can come along for free. A special public event to celebrate 50 years of Forensic Science Ireland is going to take place at the National Convention Centre in Dublin on May 28th. The doors are at 6 p.m. and tickets are available now on eventbrite.com. Don't miss it. So, Eamon, this is like, we feel like we're in Groundhog Day each evening as you return from the courts. But of course, it will all come to an end, as all trials do. The jury are being given what do they call it? The charge by the judge.
It's kind of the final summing up of the judge's statement, or they call it the judge's charge.
Yeah.
So he's basically explaining the points of law, what the verdicts available to a jury are. He's also kind of giving them advice in what certain things mean, like, for instance, self-defense. He explains, if they have to, be certain beyond all reasonable doubt that the prosecution have or haven't managed to establish their case, and then they consider things like self-defense or partial self-defense.
And what so it's Judge Paul McDermott.
Judge Paul McDermott, yeah. And
so basically this jury have sat over 4 weeks. We're into the 5th week of it now, and they've heard the evidence, they've heard the experts, they've heard the police teams, a number of them. They've heard his interviews that were done in the aftermath of his arrest. They've watched them, and they've heard what the state's case is. The state is stating that Satchwell murdered his wife, Tina. They've heard amongst this evidence what admissions Satchwell made under arrest, which were, he told a story about her coming for him with a chisel, and they had this sort of grappling argument. A dressing gown rope ended up in his hands, and he says she sort of fell on it, essentially, was the story. So they've all this to consider. So it's a bit confusing, isn't it, really, for a jury? So this is where the judge steps in and he says, right, you've got a few options here. And he's told them today that they've one option. They can return a guilty verdict for murder. And we'll explain in a minute what sort of boxes they have to tick for that. They can return a manslaughter conviction, which is a completely different thing. We'll talk about that. Or they can acquit him totally. So how does Justice McDermott sort of define things for them, and how does he tell them they should be moving forward at this point?
Well, he starts off with, I think, what they more or less term the general principles, and he reminds them that they are the judges of fact. His job is there for points of law, and he mentioned that there had been there are points of law that had to be decided, and they did that in the absence of the jury, but they're there for the facts, and they're there to give a true verdict in accordance with the evidence, and that he has no part in deciding that. He said, like, he was kind of giving his introduction, saying that he was going to also summarize the facts of the case, and that if he gives certain emphasis on facts, if you disagree with that, he says, that's what you're here for. You have to approach it with an open and an independent mind, without emotion and without prejudice. And he said, like, there's elements of this case that may seem unseemly or shocking. And he says, any emotions you have to leave outside the jury room door. You have to look at things in a careful and clinical way at where the evidence leads you. This is to get to your verdict. And he says, the reason you're here is because of your life experience and your common sense. How, you know how people engage with each other. And he says, and don't leave that outside the door either. He's explaining then, reminding them that anyone charged with a criminal offence is presumed to be innocent of it. And it's up to the prosecution entirely to prove that someone is guilty of an offence. He said it's a significant and overriding principle that applies in any criminal trial, and that even now, as I'm speaking to the jury, as he put it, he says it still applies. He says proof beyond all reasonable doubt then. He was explaining what that means. They have to find it's been proved beyond all reasonable doubt that the prosecution have succeeded in saying this is murder. And he said it's the highest standard available in the administration of justice. He said the mere suspicion of criminal offence or reasonable suspicion or the likelihood isn't sufficient for proof in a criminal trial. He said that the standard of beyond all reasonable doubt it's not beyond a mathematical possibility, but it's the highest standard that's available. And he used the example of reasonable doubt. Then he was giving them an example, like if you're considering moving to another part of the country, selling your house, whatever, and moving the family, and there's something just makes you hesitate, that you feel there's something missing. That's the kind of doubt, he says, is a reasonable doubt. He said it's not an impossible standard, but it's a very high standard, and it's the one that they have, as the jury, they're obliged to apply.
Mm-hmm.
He also addressed them about how, when considering the evidence, about how they're to consider evidence. He said, the burden again reminds him it lies entirely on the prosecution. He said, you've heard people in the witness box, you've had statements read to you, you've had exhibits shown, you've looked at some of the interviews with Gardaí, the lengthy media interviews were shown. He says, he reminded them that they're confined to what they heard in the courtroom. And he said that was why he was explaining, when they leave the court, the jury room, they're not to speak to anyone else about it. And he said the significance that members of the jury place on any piece of evidence is entirely up to them. And he says people have come to court, they've given their evidence, and it's up to them now to weigh their evidence as they think fit. And he again explains that the nature of the evidence varies from witness to witness. There was guards, civilians, and expert witnesses, and they have to assess what they're saying. He also mentioned, well, that sometimes people have memories that let them down. And he says that happens from time to time. It doesn't mean they're lying. And he referred to some parts of the case where people, said like, well, this is how I remembered, but my statement was close at the time, and that's the version of events I'm going to stick with.
Did he refer to a particular witness there? Or?
No, but there was, John Cohan actually mentioned that in his witness. He was asked about his statement, and the judge actually explains, like, some of the... John Cohan was one of the car boot sales people.
Oh, yes.
He was the gentleman who had the hearing aids in court.
Yeah.
But anyway, he was talking about the memories and that happens, and as he says, it doesn't mean that they were lying.
Mm-hmm.
But he mentioned that when sometimes these statements are read back, that they in themselves aren't evidence either. It's what people say in court. That's the evidence. What people say from the witness box. Now, again, look, this was, it's a busy court, and he'd actually broke for lunch at this stage, but like he didn't get started until afternoon because there was another sentencing hearing from a completely unrelated trial, and there was other case management. This is the Central Criminal Court that deals with serious offences. So when they came back after lunch, he was explaining, I suppose, about evidence and the nature of it. And he said that there's more than one view open to a particular piece of evidence. One is in favour of the accused and the other in favour of the prosecution. And he says you must accept evidence in favour of the accused unless it's, again, proved beyond reasonable doubt.
Yeah.
It's a phrase he uses over and over, and he mentioned that it's a phrase he uses over and over.
So how does he define murder, and how does he define maybe manslaughter? What are the differences?
Now, he came to that. He came to that towards the end of the day, which is why I'm scrolling down here through my many pages of notes. So, like, again, he describes murder as a form of homicide, and he says there's different level of responsibility, let's say, and one is murder and one is manslaughter. Murder is the unlawful killing with intent to kill or cause injury, and he said or cause injury, and that is very important. He said to them, he says you have all the details to show how Tina Satchwell came to her death, and he says, did Richard Satchwell cause it? He says that's your first port of call. He said the killing must be unlawful. He mentioned again that there are some types of homicides or killings that are lawful, such as a soldier in war, on behalf of the state kills someone. And the third element is the intent to cause serious injury. And
that'll be the difference between murder and manslaughter. The intent isn't there in manslaughter, but it is there in murder.
Yeah, and again, this was actually said in I think the summing up by the prosecution. He said, look, there's no way to discover what a person is thinking at any time. There's no machine. There's no magical way of looking into someone's brain to see what they were thinking. He says you can only look at the surrounding circumstances in which an act is being committed. He recapped a little bit saying, in this case, Richard Satchwell buried the body, had gone off to arrange a driving course. He'd placed the body in a freezer before then burying her. And he says you have to consider you have to consider background events if an intent was formed by the accused. And it's important, he said, to consider if the prosecution have established that. So it's up to the prosecution to decide to
establish
prove
the intent.
And they have to listen to all this evidence that they heard. And he said, again, he reminded them, the law is clear in this country that if someone dies after an assault, it's not murder if there was no intent to kill. But it can lead to a manslaughter conviction or a manslaughter verdict. And he gave the example of pushing someone over. It's regarded as manslaughter, even if there is some degree of intent. But if the harm is short of causing serious harm. So if somebody goes to push someone and they only meant to push them over and they die, it's manslaughter. There's no intention. And he gave an example of there's cases. He says there's been cases in this city of Dublin where there've been elaborate plans to kill people. Where cars are arranged, groups of people get together, they're monitoring and essentially hunt down someone. He says that's not suggested here. And he said these are all things that the jury are going to have to discover.
And discuss. And remind me, weren't we talking about homicide at the beginning of this trial because it came up for some reason in the case?
Yeah, no, it was in the opening
definition of it,
and the definition of it again. So it's being repeated.
Yeah,
it's been explained to the jury the difference, I guess, between assault, manslaughter, and an unlawful killing, and then murder, and it has to have that element of intent to kill.
So homicide essentially
intent to cause serious harm,
the same as murder.
Well, homicide is killing.
Yeah.
So you can have a lawful homicide.
Okay.
And an unlawful homicide then can be manslaughter, but but the most serious one is murder.
So homicide basically covers all of those.
It covers all killings.
And the reason we were talking about it, of course, earlier on in the trial was because during the trial in Kerry, they upgraded the case of the missing man, Mike Gain, to a homicide. And we were wondering why the homicide word was being used. It felt like an American word that was creeping in, but that's interesting. It sort of covers, it's the umbrella word for all those different ways.
Yeah, for a killing. I mean, yeah. I mean, it's unlikely in some cases that it's going to be anything but unlawful.
Yeah.
But in this particular case, that's how it was being explained to the jury today.
And you mentioned to me there outside that they were talking about, he spoke to them about this self-defense and that this is something they're going to have to consider. The self-defense surrounds really Satchwell's own narrative of what happened on the day.
Well, it was said to him, the only account of Tina Satchwell's final moments it comes from Richard Satchwell. And so it basically said one of the central features of this case has been the evidence presented to the jury where they were invited to consider self-defense. And it was put to you that he was attacked by Tina Satchwell. This is the thing about, coming at him with the chisel, and that he defended himself in the manner which he described in the interviews, which is him on his back holding the dressing gown. And he explained then to the jury there are two types of self-defense in a defense situation in court. There's full and partial. And I explained that, again, there's a statute under the Non-Fatal Persons Act where it provides for the use of force by a person, but they're allowed to use reasonable force. And one of those situations is to protect yourself from assault or injury. Now, he reminded the jury, Richard Satchwell doesn't have to prove anything in this regard in terms of whether self-defense is available to him, and it's up to the prosecution to negate anything in that regard. And so he explained to the jury, Richard Satchwell, they have to consider, did he honestly believe that the circumstances existed to permit him to use force to defend himself? And he explained that it's his belief, not the jury's, but it's his honest belief and his perception that they're concerned with. So they have to decide whether, from what they've heard in court, whether or not they believe Richard Satchwell had formed the honest belief that he could use reasonable force. And he said, if you come to the conclusion beyond reasonable doubt that he didn't have such an honest belief, then self-defense is not available to him. It's available for them. Say,
for example, if a jury should consider that self-defense and that reasonable force was used in self-defense, what happens in that case, or what were they told they'd...
In that case, he's acquitted. And he said, but he also said then, and they also have to consider what is reasonable. And what would a reasonable person do in the circumstances that Richard Satchwell believed himself to be in? And if they feel that he met that requirement, that he used reasonable force in the circumstances where he found himself in, then they have to acquit him of manslaughter and murder. And that's said to be the full defence of self-defence. Partial defence then reduces the charge of murder to manslaughter. But in that case, the jury must decide then that a degree of force was not what a reasonable person would have used. But he honestly thought it was. And he's guilty of manslaughter.
So if they believe that he believed his actions were to defend himself, that he used reasonable force, but they think he used excessive force.
He used excessive force, then it's manslaughter.
Then it's manslaughter instead of acquittal.
Instead of acquittal.
Right.
And he also said that he told the jury that the defence of self-defence is not available to people who carry out a killing because of revenge or hatred as well.
Okay. It's interesting all that, isn't it? Like that, you don't really usually so much put yourselves into the place of the jury, but it's quite a complex situation, even though some trials can look as if they're fairly black and white, but no trial really is. It's gone to trial. All these things have been placed on the table and they have to kind of go off and consider which bits they accept, they don't accept, etc. And of course, they all have to agree then. It's not as if, you're working, he's telling them they're working as an independent person with their experience of life and they have to go into that room with that.
They're essentially a panel of judges of fact.
Exactly.
And one of the areas where you can, I suppose, spoke to him at length today was on this idea of circumstantial evidence. So he said you'll often get this in criminal trials, where you have circumstantial evidence. And he said in this case, like, you don't have direct evidence of the actual killing of the late Tina Satchwell. And he says, but what you do have is circumstantial evidence, which is the accumulation of facts, none of which would lead to a conviction on their own, but taken together would lead to a conclusion of beyond reasonable doubt, which again, that phrase is constantly being used during this charge speech. And he says you have to be satisfied as well. He said, in terms of evidence, like what's inferred by this circumstantial evidence, you have to be satisfied that the inference is warranted or not. And in the case of when it's combined evidence like this, and he said, you're entitled to consider the evidence as a whole, whether or not it establishes guilt beyond reasonable doubt again. And he said, speculation is not permitted. And he gives an example of this at one point. He said, if you go into a courtroom with no windows and it's a bright sunny day, and then an hour or two later, somebody comes in wearing a raincoat and they're completely drenched. He says you can infer that it's raining outside, but you can't decide what time it started raining. Because that's speculation, and speculation is not permitted. They can't fill out the gap. They can't fill in the gaps themselves. And he says, but it's up to the prosecution. Again, he reiterates this. It's entirely up to the prosecution to prove that the circumstantial together as a combined set of facts lead to prove their case that it's murder, not manslaughter, or that he's not guilty. And he mentions in this case that they heard the prosecution say that she was going to leave him, that she'd wasted 28 years of her life with him, and that kind of his reaction to it. They're suggesting, the judge is saying that the prosecution's case is that his reaction in after her death again forms part of their case, that there was intent, which is all stuff that they have to consider as part of this. Again, like he said, even giving different version of events of what happened, he says that can also be part of the whole various strands of circumstantial evidence. The actions, again, as I mentioned, in the wake of her death, and the great lengths that that he went to conceal by disposing of her body the way he did, and telling the stories to some people that that she had gone away, that she had left him, or that she had become ill. And these are all pointed out again by the prosecution as his intention to kill, and to conclude that he killed his wife and dispose of her body. The fact that he didn't seek medical help, This is what he's saying is their case, the prosecution case, the creation of messages shortly after the killing, the email on the laptop, his engagement with the people about the monkeys on the text as well, going to Dungarvan on this shopping trip, going to relations when he knows that the wife's body was in the freezer at the time. And, alluding to the fact that she suffered from depression, she had a short fuse, she engaged in violence, and telling people the birth cert and the marriage cert were gone. It's the whole engagement with the media over an extended period. He says, drawing in members of the family into the media calls, asking Tina to come home and making those calls himself. He says, these are all matters of circumstantial evidence. And he says that they're important. They have to be carefully considered by the jury. He says they have to decide if they have the significance that the prosecution can contend they do, and that they have to be satisfied the inference is warranted or not, and has been established again beyond all reasonable doubt.
And Satchwell, is he listening intently to this himself?
Yeah, well, he's there, and he doesn't react. To be honest, he hasn't
at all.
No, he's. I mean, as the jury can see him, like he has one kind of. His one hand kind of, knuckles into the face, kind of a fist into the face, or he's holding himself up. I'm doing that on podcast now. I'm doing a demonstration, but anyway, which isn't much good. See. But he's leaning on one hand, and he's looking away from, his face kind of in the direction of the judge, but he's looking down most of the time.
And is there anybody in court that looks, as if, is there family of either of them?
I don't know, to be honest, Nicola.
It's just mainly
taking notes.
It's mainly the journalists and the kind of the court goers.
Yeah.
There hasn't been.
Well, we know that. I mean, there were family members who gave evidence last week.
Yeah,
like his half sister, Lorraine Howard, and his cousin Sarah Howard both gave evidence. So they were in court.
But they don't appear to be. So what's next? So tomorrow is. Well, the Tuesday.
The judge is he's as he put it, he's inviting the jury back at 11:30, presumably after he finished his other court business. He finished off today saying, "Look, he'd been listening a long time," and he said the next thing he's going to do is a summary of the facts. So he's going to go through the facts, or basically the evidence that was heard in court.
That could take some time.
Well, yeah, it could.
It could take some time because. Some judges will go through every piece of evidence that's been held, and they'll go through each of the witnesses. So I think it's a very... and
there was 57 witnesses. We counted them up.
And we reckon how many days of evidence was there? About 12 days over 3
No,
weeks?
there was, what day did we say it was today? 16?
Well, we said today was the 17th day of proceedings.
Yeah.
But,
and there was a day and a half of voir dires.
Right.
And then, it's about 14 days of evidence.
Right. It's quite a lot.
Yeah.
So he's going to do that. And then he will likely send them to their quarters where they start.
To the jury room, where they begin their deliberations.
What court is it in again?
We're in Court 6. In the Central Criminal Court.
So we probably won't hear from you then until the other side of this when we get a verdict.
Yeah, I don't think you need to listen to me go through all the facts.
Well, no, I don't think there's any need for anybody to hear that, because if anybody's interested, they can just go through the podcast. We have published them, broadcast them day by day. So all the evidence really that has been heard, most of the evidence that's been heard in court are in those days of the podcast.
We pretty much recapped.
And I think we clearly labelled them day 1, day 2, because we haven't done that previously in court cases. We're always learning here.
Yeah. And we're out of sync with one or two of the other media areas.
Yeah.
Because we didn't include the arraignment day.
Yeah.
And we didn't include one of the voir dire days because it wasn't evidence.
There
were days in court. So that's why, if you're wondering why Crime World is slightly different. So we stayed with it.
Yeah, we stayed with it.
Today is day 18, I think, wasn't it? Is that what you said?
Yes. Don't be asking me questions about numbers. So I think that it'd be a good day. Anybody who wants to go over the evidence again can do so on the podcast. And Eamon, we'll see you when we have a verdict, and we can discuss then what has gone on in the in the jury room. Okay, thanks a million.
It was a pleasure, Nicola.
You'll miss it. I'm Nicola Tallant, and you're watching Crime World, a podcast about criminals, drugs and the underworld in Ireland and across the globe. Make sure you subscribe to our channel and turn on notifications so you can be the first to watch all our latest episodes. You can also listen wherever you get your podcasts.